Hello and welcome to the second session of the Certified Local Government Virtual Summer of 2020 Training Series offered by the North Carolina State Historic Preservation Office. My name is Christy Brantley and I am the Local Government Coordinator. Ideally, we would be bringing portions of this training series to your community, but because of COVID-19, we are offering training in a virtual format this year. At least one session per week will be released in July and August and uploaded to our North Carolina Department of Natural and Cultural Resources YouTube channel. Once a video is available, we will send out a notification with the web address through email and our North Carolina Preservation listserv. If you would like this session to be counted towards CLG training requirements for the 2020 federal year, please submit a brief summary of what you have learned to me at christy.brantley@ncdcr.gov. That's KRISTI.BRANTLEY @ncdcr.gov. Please include your name, the name of your commission, and the session title in your email. Our second session will be an overview of the North Carolina Local Preservation Enabling Legislation presented by Ramona M. Bartos. Ramona is the Deputy State Historic Preservation Officer for the state of North Carolina. She earned a Joint Master of Historic Preservation and Juris Doctor from the University of Georgia, and she worked as a local government attorney for a decade before joining state service. I'm looking forward to hearing Ramona's presentation and appreciate her willingness to share expertise with us. I will now turn it over to her. Hello,
Good morning,
Ramona.
Christy. Good morning. Thank you for asking me to participate. And I want to say hello to everyone and tell you how delighted we are that you're able to join us in this fashion. We hope to get back out with you with face-to-face training in the near future, but we're glad to be joining you virtually today. So I'm going to go ahead and share my screen at this point and start the presentation. All right, so many of you may have heard this presentation or a form of it in the past, but we have a few new developments this year that are related to some codification work that the General Assembly, along with the State Bar, has been working on to consolidate some of our local planning and zoning laws in North Carolina. So we're going to talk a little bit about that and then start the presentation as well. So without further ado, a couple things that I'd like to try to assist you with at this point through this presentation is, one, to give you an elevator speech so that when constituents, neighbors, fellow citizens ask you, what is it that you're doing as a local preservation commissioner? What is the function of your commission at the local government level? What does that look like? Why? To give you some talking points to that end. How does it function at the local level? What are the legal origins of local preservation? And then help you connect the dots. What is the relationship between your local preservation program and the federal and state laws dealing with historic preservation in North Carolina? And then also, I really want you to take away from this presentation what the extent of your legal authority is and what it isn't, and how do you go about performing your public service role as a preservation commissioner and a preservation partner throughout the state of North Carolina. So we'll do a little bit of civics basics this morning. Of course, we have the federal government and we have the state government, and just keeping that distinction in mind is helpful to understand the different roles that are played at the federal level and then how that relates to the state and local government programs. So for one, we have the National Historic Preservation Act of 1966. Which was part of a raft of bills, laws that came into play during the Johnson administration. This established the National Register of Historic Places, which many of you are familiar with. Most communities in North Carolina have some properties that are listed in the National Register of Historic Places. It also established the state historic preservation offices. Every state and all of the territories, Puerto Rico, the Virgin Islands, et cetera, also have historic preservation offices. And that's where Christy and I work. It also established the local government program as far as the certified local government program goes through an amendment in the 1980s. We also have a special component to the National Historic Preservation Act called Section 106, and we have a branch of our office that deals with that. And that is the federal law that requires federal agencies as they plan for, fund, permit, or approve projects. How do those federal agency actions, those quote undertakings as the law refers to them, how does that affect historic properties? And again, that we're looking for that part of the law for properties that are either listed in the National Register or eligible for the National Register. And the point of that is we're trying to either avoid the adverse impact, minimize it, or mitigate it. That's a whole other presentation we could do unto itself, but we wanted to let you know that existed. And there's also a citizen's guide to Section 106 that you can look to at the Advisory Council for Historic Preservation, achp.gov. And Christy can send that link around through the listserv later on. And then, of course, on the state side of things, we have the state of North Carolina. Local government's function is what we call creatures of the state. They are brought into formation created by the various states. So that's both at the county level and the town or city level. So keep this chart, if you will, in mind. So again, in my effort to help you connect the dots and have that elevator speech, is a great deal of what we're doing at the local preservation program level is derived from the 10th Amendment to the U.S. Constitution. And I'm going to break a few rules when it comes to PowerPoint, and I apologize for that. But when it comes to the law, the words are very important. So we're going to have a lot of text, but you can always stop this because it's going to be a YouTube presentation and take that in. So the 10th Amendment is one that you might not hear about as frequently as you do the other amendments of lower numbers, the 1st, the 4th, the 7th, etc. But this is extraordinarily important to understand the relationship between what the federal government is doing, what is assigned to do under the Constitution, and what the states are responsible for. So the idea here is the power is not delegated to the U.S. by the Constitution. That's things that we think about, like declaring war, dealing with foreign governments through treaties, printing money, that kind of thing, nor prohibited by it to the states. Again, we're not out dealing with other countries as the state of North Carolina, that kind of thing. They are reserved to the states respectively. And what I like to explain here is this: if you've ever lived in another state, you learn quickly that there are distinctions between different laws. The one that comes to the forefront when you travel around is what the cell phone permissions are as you drive. In North Carolina, there's no prohibition on driving and talking on the phone. In other states, there's a very strict prohibition on that. And that's one of the elements that I'm trying to point to here. The probate laws of the state, divorce laws of the state, they can vary tremendously as you cross borders. So the idea here is that the states get to tailor the legislative solutions to these various issues that the federal government has not been assigned per se under the Constitution. Then the final part of the 10th Amendment is where we derive our amendments from. For example, the 18-year-old vote that was passed in the last 50 years or so. So there you are. There's the 10th Amendment. So there's our constitutional basis for local preservation. So let's keep continuing to connect the dots. So looking back at our chart again, what the federal government isn't doing or can't do is left up to the states. And so there's a variety of categories. We've talked about some of those, traffic laws, etc. When you start looking at that, it's through delegation, through what we call enabling legislation. And that's how the state laws trickle down to the local government. So let's talk about how that works in practice. What the 10th Amendment is really allowing for and I hope there's a chuckle on your end when I showed you this slide. If you're not familiar with the Andy Griffith Show, it is a North Carolina-based sitcom, but it allows for something that's a legal term of art for something called the police power. And it's not so much to do necessarily with strictly the police as it is with sort of this overarching rationale for government, which is several things: to attend to protect, to regulate, to promote, sort of this triumvirate of issues: public health, safety, and welfare. And you might ask yourself, well, what does preservation have to do with public health, safety, and welfare? Well, public health, we can think about what is going on inside of an abandoned building, that it might be an attraction for vermin. There can be safety issues, whether or not the building is in danger of collapse. But then welfare is this larger idea of the general welfare. And there's lots of educational rationales, economic rationales, quality of life, remembering our past rationales that focus in on the general welfare. So remember, this 10th Amendment is much larger than just historic preservation, but again, looking at that general rationale for government. And so some examples of the police power that you are likely very familiar with: one is public health regulations. This is part of going into a restaurant and having the ranking for what we might expect, how the kitchen is kept. And how the food is prepared. Building codes, we like to have building codes to make sure that buildings are structurally sound and do not pose a safety hazard to those inside the building, or outside the building for that matter. Zoning ordinances. Not all parts of North Carolina have zoning, but those that do have found it to be an exercise, a legitimate exercise of the police power to help provide some consistency as far as what kind of development may come to a particular part of town. And if it's not something that was already zoned for X, Y, or Z, there's a process to go about rezoning it with public input. Subdivision regulations. Subdivisions, are a popular kind of land development in North Carolina as well as the rest of the country. But when you are maximizing more development on a particular piece of property, that requires more fire coverage, more seats in schools, more utilities, and all of that needs to be figured out as well. Pollution controls. Well, where does our water come from? Where does our air come from? What is intervening before it gets to you? Environmental regulations. Sign regulations. Now, sign regulations, I will say there's one little element to this, a very large element to this, and that's the First Amendment. Just as a reminder, as if you have sign regulations embedded in your preservation ordinance, it's really time, place, and manner that you're allowed to regulate, not the substance of the expression, which is protected by the First Amendment. So this is the family of the police power, so to speak, and historic preservation ordinances are just as much of a legitimate exercise of the police power as these other aspects that I think we could all say have a lot to do with quality of life issues. So here's a little bit of new information for you. If you have seen this kind of presentation before, or if it's brand new, even better place to start. There has been a multi-year effort in North Carolina, a very cooperative effort through the Bar Association, state legislature, and practicing planning professionals to try to consolidate the way that we have development and land use regulations. They have been embedded in something called, a chapter is the categories of the law, the way it's codified in the general statutes in North Carolina. So they have been in chapter 153A, and our favorite number for preservation has been in 160A. And what they've done is they have taken and tried to consolidate all of these from these very places into one single unified chapter and have more of a logical, coherent organization. So there's not a lot in the way of major policy changes. I'm most familiar with the historic preservation side of things, but there has been an effort to have some clarifications and some consensus reforms that are being folded into local development regulations. So 160D is effective as of now, as of June 19th, 2020, but local governments have until July 1st, 2021 to amend their local ordinances to be in compliance with these new laws. So if you are a planner, you probably know all about this. If you are a commission member who does not practice their profession in these areas, might be news to you, but this has been very discussed for, gosh, over 5 years at this point. So now we're here. So what you will see, and I have sort of a highlighted teaser here where I have clarifying amendments and consensus reforms in this bright yellow. What I want to do is try to give you the new citations. I have 160A, 400 point whatever in my head, but we're going to have to all together get on the 160D new citations. And where we have had some of these clarifying amendments, and there are very few actually in the local preservation enabling legislation, but where we have had a few of those come into play, I will highlight those in the slides as well. So you might want to take some notes as we go forward, particularly if you have already been a preservation commissioner prior to now. If you're a brand new preservation commissioner, you're coming in on the ground floor of these changes, which again are not overarching, or they have not completely reworked everything. So just as we go forward, I will try to point those out to you. And by the way, I will say there is a book if you want to invest a couple dollars. The School of Government at University of North Carolina, Chapel Hill has a series of videos and trainings about Chapter 160D and the larger scheme of things, not just focused on preservation. And there is a book that breaks this all down, and this is where a lot of my materials have come from. It's Professors Owen and Lovelady have come up with this book, and you can order it off of their website at the School of Government for the University of North Carolina at Chapel Hill. So let's start at the very basics. The enabling legislation allows for local preservation commissions to be set up, to be established by local governments, and that's by a local governing board. So that could be a city or town council, or it could be a county commission. There have to be at least 3 members. We really recommend as a best practice that you should have an odd number of members in case you have a tie situation. You can break a tie, of course, with an odd number. Terms should be no greater than 4 years. Your bylaws can certainly talk about term limits if you'd like, or if you just like to encourage as much service as someone is willing to offer. Now, the majority of the individuals have to have what is deemed demonstrated special interest. And I want to stop with special interest. Special interest is sufficient. Special interest is sufficient for the statutes. It's also sufficient for the Certified Local Government Program, which Christy is going to bring you some more information about that if you're not already a certified local government. But experience or education is also a wonderful thing. So, but special interest, experience, or education in history, architecture, archaeology, or related fields. So we would really like to see individuals that have, per the state law, that kind of at least interest. And this next one, there's a little bit of a change. It talked about territorial jurisdiction, but now they're saying planning and development jurisdiction. And that is, if you're familiar with what that is whatever the jurisdiction is that that particular local community has that is subject to its planning and development rules and commissions. So that's something that you'll need to check in with your local city or county attorney on to make sure as you start to recruit new members, perhaps to make sure that distinction is now being made. It's planning and development, not just the territorial, which was in 160A. 160D is now planning and development jurisdiction. Commissions can come in a variety of forms, and there's not one right answer. The right answer really is what works best for your community. A historic preservation commission has the ability to do it all. In other words, they can look at both local landmarks, which we'll talk about the distinction between that and local preservation districts. A landmark is generally one piece of property It may or may not be connected to anything else or adjacent to other historic properties that might be by itself in a, say, a more developed area versus a district, which might be the old neighborhood or the old commercial area of town. So that's the Preservation Commission. They have the ability to do both the districts and the landmarks. Then you can also have a landmarks only commission or a districts only commission. And you see that in communities. I'll give you an example. Charlotte-Mecklenburg County, the county handles landmarks. The city, I believe, does only districts. So but there's a cooperation there. So it just depends. Many counties that want to get into this because they're working in the unincorporated areas, which are not, it's kind of like a donut hole. The incorporated areas would be the municipalities. The counties oftentimes will look to landmarks commissions, as that works for them because of the more scattered nature of the historic properties. We also have a few communities that select the planning board approach to historic preservation commissions. Oftentimes it's maybe a smaller community where you don't have as many citizens to draw on to serve, but a planning board can function as a preservation commission if you've set up the ordinance that way. And off the top of my head, I can't think of any communities that have selected a community appearance commission to take on the role of a historic preservation commission, but that's also another option. So the ordinance or your regulations have to outline if you pick the planning board or community appearance commission aspect. So there's different flavors, if you will, to preservation commissions that state law allows. All right, so this is always very interesting for me to read in other states what the legislative findings were. What is the purpose behind setting up a particular law? So in North Carolina, our current law, the 160A that has now morphed into 160D, new numbers, same law. The 160A package was passed in 1989. So I mean, we're a good 30 years into this now, and it's been readopted as of 2020, and the findings are still there. So it's the idea that our historic properties, our historic built environment, one of our most valued and important assets. And I put the dollars there because they do talk about increasing and stabilizing property values and strengthening the overall economy of the state. But preservation is not just about the economic side of things. There's also this idea that preservation helps us to understand our culture, history, and architectural history. And I also mentioned prehistory. We do have archaeological areas in North Carolina that also need protection. We just oftentimes, though, think of what's above the ground. And we also want to promote the use, not just to look at, but the use of these properties. And again, looking to education, pleasure. It's not often you see the word pleasure in a law, but there it is. And enrichment of the residents of the local community as well as the state as a whole. So it's really looking at it in a very comprehensive, why do we preserve? And we probably will offer as part of our virtual series, the Why We Preserve presentation at some point, which builds on some of these concepts which our legislature has codified back 30 years ago and has now just been renewed. So one of the things that commissions really need to be embracing, and I'm so glad that we work in partnership through our survey program for our statewide architectural survey, but it is a power of the commission under state law. And it's something that really helps you as a community figure out what it is that you want to preserve. And that is to do a survey. And when I mean survey, I don't mean going out and measuring property. I mean looking to see what is there in terms of your architectural and other historic properties that you may have. We have been doing survey in North Carolina since the beginning of the program in the early 1970s. And we have over 125,000 properties that we have, the state of North Carolina has a file on. And much of that work has been done in collaboration through this kind of of effort with our local governments. We also have certified local government money that's available if you're one of the 50 plus communities that can apply for our seed money, federal money, pass-through money. But the reason you want to do this is how can you figure out what it is you need to preserve if you really don't know what you have? And one thing I will say is we've been doing this since the 70s, 80s until today. We tend to look at a 50-year back in time. So if the last time that a survey was done in your community was 1990, that means you stopped at 1940. And whatever has happened between 1940 and 1970, which can include some of our mid-century modern designs, which North Carolina was really in the vanguard of that during that design period, you don't have that recorded. So if you don't have that recorded, we don't have that recorded, it's harder to try to justify and explain why it is you're trying to preserve it. So we really would like to come back and help you do an update if you have had an older survey, particularly if you were a community that was growing during that time period. Again, post World War II, generally up to 1970, because now 1970 is 50 years ago. So the other thing I'd like to do, and we'll have a presentation about this as part of our series, is do you need, your time period may be fine, but you've only been concentrating in particular parts of town. So do you need to broaden the focus? We've been thrilled to have a number of African-American historic resource surveys in the last few years in collaboration with our local preservation partners. So do you need to broaden the focus? Or maybe there's industrial history that you have not told the story of because you were a mill town, for example, or manufacturing community. So there's lots of different approaches to this, not just the chronological, but also the thematic. And I think being as comprehensive and all-embracing with that is going to help you very much with your preservation program. So let's say you've done the survey, you've done your inventory. Now it's time to figure out what you would like to designate that you would like to have some local oversight over. So here again, and you see the this really hasn't changed, but again, I'll just flag for you, the citations have changed. What is it that you're trying to preserve? A historic district is an area. It can be a small area, it can be a very large area. Oftentimes communities will try to overlay that with National Register. There's nothing wrong with doing that, but you need to ask yourself, does that tell the whole story as far as what you want to do? You have a little bit more flexibility at the local level. But it does set up an equation that is patterned after the National Register. One is, what's the special significance? What is the story of the property? And you can tell that story through history, prehistory, architecture, and then there's something that's not defined in the statute, but culture. And that can be something that you would launch the articulation of why this is a especially significant place in your community. So that's the one part of the equation. The other part of the equation is what we call integrity. And integrity is not a judgment about character. It is more a question of the fabric. What is there, the physical representation of the story? And so we look to even more aspects of what we call integrity through the National Register program, but you want to look for if it's architecture, design. And we've heard from Hannah Beckman, our colleague, Hannah Beckman-Black, last week on architectural design. Some things are very high. Setting, is this still a farmstead? What is the situation there? Feeling, this is part of the National Register question that has been now imported into this particular law. Is there a historic feeling that you have? Is it associated with a particular area, or is it associated with a particular place that, this is where all the manufacturing was set up in your community, for example? Now, landmarks have the same criteria, but on the integrity side, under that statute, they add or. So I'm not sure why that is, but there it is. So again, you have to have both sides, and Christy is taking in all of our landmark and district reports as this comes forward so that we can help give you feedback on whether or not that, that argument has been made for the designation. So that's the character that you need to have in mind when you start thinking about designating properties for local oversight. So how do you do that? How do you do that? Well, first of all, and I have the word design guidelines here, and we're going to talk about that particular expression. That is lingo that preservationists have been using for 4 decades. Design guidelines. We're going to up that a little bit now with this new 160D, and we're going to start calling it standards. But they're really still what we have always thought about with design guidelines. You need to have some rules of procedures. That's bylaws. You know, how does your meeting run, that kind of thing. And the design guidelines, now standards, can be what I say basic SOI. And we're going to have a presentation out this. This is the Secretary of the Interior standards, usually for rehabilitation. But you have to have some rules for how you're going to enforce your design review before you start designating. And a lot of communities, especially when they're first getting started out, they will just select those pre-established 10 rules that the Secretary of the Interior at the National Park Service has set up for how you treat historic properties. But then we really would like to see you ultimately have a more tailored set for your community, which we'll talk about in a few minutes. But you need to have that set up. How does this happen? Well, there has to be an ordinance or regulation passed by the governing body to designate. So this is really a legislative decision. This is something that the elected officials figure out. Now you, as the Preservation Commission, will be the group that puts this forward generally. And on the district side, you see that on the left-hand side, it can be an overlay or it can be a separate use district. There has to be an investigation, a report, and again, talk about that significance, the integrity from our last slide. And for the district, what's the boundary and why are you selecting that boundary? On the landmark side of things, you also need to have a report. Usually it's an individual property, which doesn't have to necessarily be out by itself. It can also be inside of a local district, and that's common to see. And we'll talk about why people want sort of that double layer in just a moment. On both sides, you need to have this sent to our office, to Christy Brantley, our local government coordinator. Our office then gives feedback to as far as what you have said, and oftentimes has advice regarding how you can strengthen your argument or just saying everything's great. For the local districts, this is a little bit of a change. The way that you go about designating is you follow the same rules, and this is something that your staff will be helping you with for zoning regulation adoption. On the landmark side, it's a legislative hearing. And again, this is all part and parcel of what your staff should be helping with to shepherd this process through. If there's a historic district, it's the oversight, it's the design review, but there's no property tax deferral unless it's also a landmarked property. If it's a landmarked property, either in a district or by itself, there is a 50% local property tax deferral. And then the regulation, the ordinance is filed with the deed register. The tax officials then find out about it as well. And, you know, if you were owing $3,000 a year and your landmark, now it's $1,500 a year. And that is for as long as the property remains a landmark. So you can imagine that's a great incentive for individuals to seek that landmark status. So just to reiterate, and this has been emphasized in a case that came out early on in North Carolina, the ASP Associates versus City of Raleigh case from 1979. We had versions of enabling legislation or local legislation that allowed for local preservation before 1989. And so that's why that's here. Just the scheme that we have now was codified as it is now in 1989. But this still holds true. When you set up a historic district, or I would say a landmark as well, again, it's your governing board that's doing that. It's not the Preservation Commission. You're making a recommendation generally, but it's really up to the elected officials to figure out how to go about doing that. How the district or landmark is administered and there's design review, that is up to what is limited discretion in your hands as the Preservation Commission. And this is, we're going to talk about something called quasi-judicial decision making. And so the cookbook, you're limited to a cookbook, so to speak, that's set out by the enabling legislation we're talking about, by your design standards, as we're going to call them now, and the bylaws of the commission. So your world of legal authority is limited to how it has been set up by the elected officials, and you're carrying forth that program based on those aspects of the program. So I hope that makes sense. So local commission powers. Again, we've got a new citation, but it pretty much stayed the same. The one that most people think about if you've been in the commission world for a while, or if you're brand new, is you'll hear about something called issuing certificates of appropriateness. Well, that's the permission, if you will, for changes, new construction, et cetera, that may happen that deal with that are happening within the designated areas that are subject to your purview. Now, I point this out because that's not all you can do. That's not all you should be doing. We talked a little bit already about inventorying properties, surveying properties. That's the identification designation part. Then that leads, hopefully, to some local designations. But then there's a whole other laundry list of frankly, powers that fall under more of an advocacy and education standpoint. One is, your commission can actually acquire property, including options to purchase, hold that property, sell and lease. The Charlotte-Mecklenburg Landmarks Commission has been doing this for a long time. I think they're one of the few commissions in the state that do this, but they're following through with the state law by doing that. You can also restore, preserve, operate historic properties. Not a lot do that either in the state, but many, and I would say if you're not already doing it, we'd be glad to help you start, is conducting an educational program. And that is to help your neighbors, your fellow citizens in your community understand why these places are important, why they should have preservation orientation around them, because everyone's marching on in time ourselves, and it's good to keep telling the story so that we have the next generation understanding and appreciating these places as well. We also would like to be cooperating with you. You cooperate with us, we cooperate with you. And that's again through our efforts, through our state laws we're talking about today, but also our federal government and other parts of your local government as well. Certified local government grants, we have money that we'd like to help you foster some local preservation projects through. So that's part of what that's about. Another important aspect, and again, this gets a little bit of short shrift, is whether or not you are helping with a preservation element in your local comprehensive plan. You can also have a standalone preservation plan, which is a great thing to do. It gives tasks and goals that you want to see happen in your community, but that's really, really important. And then of course, back to negotiating, back to that idea of acquisition for preservation purposes. So it's interesting that it seems like in all of our feedback that we get from year to year, the vast majority of time that commissions spend seems to be on design review, which is very important. But I just want to remind you, there's this whole other aspect to the powers that have been granted you by the legislature. And we'd really like to see you embrace them all, not just necessarily concentrate on one particular power, as important as it is. So if you are going to do preservation at the local level and have a commission, there is that design review component. Now, what is it that triggers the certificate of appropriateness? It is required, again, we've had a change in our citation, I'll flag for you again. If someone wants to erect something, build something, alter something, restore something, move something, or demolish something. Now, what is that something? The exterior of buildings. It can even be masonry walls, fences, light fixtures, etc. What we call appurtenant features. They're somehow supporting that property or serving that property in some way. Above ground utility structures. Signs, and what did we say about signs? We've got the First Amendment that we need to always remember there. Now, that's really the envelope of the building, the footprint of the property. Now, interior. A lot of people will ask about interior. It's a great question. We're only going to be doing interior oversight, design review, only in public landmarks or private landmarks with the owner's consent. And so very few places that are doing that. And we can have some questions about that through the listserv if you'd like. But that is, I think, a misconception is that local preservation is looking at inside and outside. That's not really the case. Vast majority of the time, it's the exterior of the building. Only in very limited circumstances is it the interior. Now, if your local regulation states the following, you can also bring this into your oversight. One is historic signs. We've talked about that in the First Amendment. Color. Now, there's a lot of policy issues. There's a lot of pros and cons to color. That's up to your community if you'd like to do that. I will say color can be something that in the bigger scheme of things might not be nearly as important as not painting masonry, not painting brick, not painting stone, because that painting of stone, painting of brick, regardless of what color you paint it, will change the way that those materials behave and function, and you might not be satisfied with that. So color, again, that's up to the local community, and we have a number of communities that do color, but not as many as I think the public would think. And again, it's up to you whether or not that is an aspect of regulation you would like to follow through with. We also have the ability, again, it's a discretionary, it has to be included in your ordinance, significant landscape, archaeological, and natural features. And again, if you're going to try to have some oversight there, when you do the designation, you really need to make sure that you are covering and articulating what those aspects are. Because if you don't, I would say it's more difficult to try to regulate those. Now, the exterior. What are we talking about? The exterior of a building? Well, the materials, you know, is it clapboard? Is it something else? Brick? Size and scale. That's the size and scale. Height. This really comes into play for additions, for example. Type, style of windows, doors, we would call that fenestration. You know, the eyes of a building are usually its windows and doors. Now, how do you do that? Well, you have a process where someone comes and asks for a certificate of appropriateness for any of those activities that we have outlined on the left-hand side of the page. Now, a COA should be obtained before the building permit is issued. And I would say even if there was a building permit out there, maybe it was for the interior, but then things moved past the interior, there needs to be some way in your local government as a flagging system so that if there's an amended building permit, do you have a COA? Do you need a COA? And a COA is required even if there is no building permit required. And we have to follow, in making these decisions, principles and standards. Now, we used to call this principles and guidelines, design guidelines again, but the new 160D is making clear, and I'll explain why in just a minute, that we're looking to principles and standards. That way, when all of our constituents come to us, they know what it is, how it is you're going to make your decisions based on principles and standards, which are mandatory now. I'm just reemphasizing that. So again, that discretionary aspect, I just flag that for you. Make sure it's in your ordinance and make sure that you really do want to have oversight over those features. Now, before we talked about, you have to have bylaws. If you haven't had bylaws, you probably need to go back and revisit that. And if you do have bylaws, you probably need to revisit it to see, are they working for you the way that they need to be working? Principles and standards, we're going to follow those. We're going to talk about what that is in just a moment versus what we used to call guidelines. We might still call them guidelines as preservationists, but for purposes of the legal aspect here, we're going to call them standards. Now, there is an ability in the statutes. Not all COAs have to necessarily go through the commission. And so this might be a constituent service point that you would like to investigate more or expand upon. For example, if it's a simple thing that someone wants to do, there might not be any reason for them to come to the commission and have, a half an hour discussion about it when it's like, well, that's a slam dunk approval anyway. So there is the ability to set up a list of minor works that can be approved at the staff or administrative level, and you don't see them necessarily. However, if there's something that needs to be denied or should be denied, the commission only can do that. The staff administration cannot do a denial. They can only do an approval. And minor works are a good way to figure out how to streamline your operations. One, for good constituent service, and two, so that you can spend more time, not necessarily on COAs, but you can on those other powers that we talked about, the education, outreach, survey, inventory business. So this is a new change that is emphasizing, I think most commissions were already doing this, but this is to emphasize and to put the preservation commissions in the same path as you will planning and zoning commissions, etc. These are all land use decisions. This is more of an aesthetic regulation, but it still is under the rubric of land development, zoning development. So you have to use a quasi-judicial decision-making process. This is now part of the regulatory program for local preservation commissions, except for those minor works, which your staff is approving administratively. You don't necessarily see. You need to follow the quasi-judicial rules. Now, this is mandating this because they want to have a standard process across the state for all quasi-judicial decisions, for all land use decisions. Because what had happened before is, this was handled a little bit this way and this one was a little bit different over here. We're going to have a consistent basis in North Carolina from now on. So the nature of a quasi-judicial decision is similar to a court decision, where we have a general law. In this case, will be your regulations and our state law that deal with how do you handle certificates of appropriateness, what are your standards, what are your design guidelines. Again, we're going to call them standards, but what are the design standards here? It's got to be based on evidence and those standards. And the commission, you are all kind of like a panel of judges. You're using judgment to adjudicate how that regulation applies to that particular situation. If you really would like to know a whole lot more about quasi-judicial work, there are a series of training modules and so forth. Again, at the School of Government's website at Chapel Hill, there's also this book. I always call it the egg yolk book because we have this nice yellow and white Q for quasi-judicial. And again, you can easily order this and read up on that as well. Some of this may or may not be a little out of date because of 160D, but 160D does talk about quasi-judicial in that book that I referenced for you as well. So the standard for review, let me go back for a second. Part of what is happening, if you've never been to a quasi-judicial, and I assume most of you have, is there will be a swearing in of witnesses, which are the applicants, others who have a right to speak about this. And then you'll have your evidence, that's your application, that's the materials that are presented at the meeting, that's the testimony of the parties that are participating, and there's an actual there's a formality to this in a hearing. And again, it's to help everyone understand what is going on and to be transparent about how you're making your decisions. So again, there is a great parallel between sort of a judicial, why they're saying quasi-judicial. You're not judges, but you're functioning in a realm that's very similar to that. So the standard for review, and I need to update this, it's no longer 168-400.9, the commission shall take no action except to prevent that which would be incongruous with the special character of the landmark or district. Now, what does incongruous mean? It's not defined in the statute, but if you look it up in Webster's, it's not harmonious. It's clashing in some way. Doesn't mean that it's perfect. It doesn't mean that it is a complete replica. It just means that it's incongruous. So the thing is, this is a contextual question. You can only answer this question if you know what the special character is. And where do you find the special character? The special character you have to understand what the total, if you're talking about a historic district, and this is from that case that I was telling you about, the Raleigh case, the old Raleigh case, it's still good case law. You have to understand what the entire physical environment of the district is. And where are you going to articulate that? The best place to articulate that is in your designation report and ordinance where you set this up to begin with. That is then the source for your standards, because the standards are their purpose is to reinforce the special character, whether it's for the district or a landmark. But that incongruity, you can't answer that question, what is incongruous, what is clashing, what is not harmonious, unless you know what the context is to make that judgment. So where do you find that? Again, this is part of our helping process with you by our review at our level. The state office is to help you make sure that you're articulating that special character. Question is, for these old ones, are you saying enough of what the special character is? And when someone comes to you for an alteration to the district, to the property, changing this, that, or the other thing, the design guidelines should help, old design guidelines, principles and standards should help reinforce that special character so that it can continue to be preserved. Because things can change in the aggregate, and we'll talk about what that looks like in just a second otherwise. So here's the principle and standards language. And I've marked out through the strike through, they've gotten rid of the word guidelines and they've replaced it with standards. And they've also added in new language that's underlined. This is to guide the commission in determining congruity with the special character of the landmark or district. And again, we're looking for new construction, alterations, additions, moving, or demolishing. And this next, underneath, you will see this is a footnote from the 160D book that Chapel Hill School of Government has put out. The standards mentioned are binding. They're not suggestions. They're not just sort of, well, that'd be nice if we followed that. No, they're binding. They are mandatory to follow. They are binding for decisions on quasi-judicial certificate of appropriateness decisions. The term, if you use guidelines, could imply that the standards are advisory, which they're not. They weren't before, but they're emphasizing through the statutory language that is new that they are not advisory, that they are the actual mandatory binding standards for decision making. So that is why we're doing this, because I think some communities there was concern that the guidelines were seen as just that, guidelines, like that'd be nice, but we're going to go over here. That is problematic from a predictability point of view and a due process point of view for constituents. So again, that's why we're probably going to still use the lingo, the preservation lingo of design guidelines, but they're not really guidelines, they're standards. And we probably will start going to that new term just so we help reinforce what the law is now requiring. So I want you to think about these principles and standards in two ways. One is back to what the new language is. They are standards to guide you, commission, in determining congruity with the special character, because we don't want incongruous, we want to try to have some congruity here. So it's the mechanism to help preserve that special character. And it's also the standards to inform your quasi-judicial decision-making. Standards, they're not advisory, they are mandatory, they are binding. So why do I have these pictures up here? Well, on the left, you'll see this is someone's face with pixels from a television screen or a monitor. And on the right, this is an ancient map of the town of Madaba in Jordan, in the country of Jordan. And both of these function the same way. Pixels on a screen, you got little dots of light. If you get up close, you just see the dots of light. You get away, you see the bigger picture. The same way with mosaic. This is a stone mosaic. When you look at this up close, you'll see little dashes and dots and squares of color. If you change enough of those, and this is kind of the design review idea, if you change enough of those, the entire picture changes. So what you're trying to do in the aggregate through what can be seen as very small scale changes, it's the small scale changes in the aggregate that unless you have the mechanism to try to keep that appearance, you eventually will not have that, that special character through the physical representation. So I hope that makes sense. I really am drawn to this kind of metaphor because I think sometimes it's like, why do we care about the windows? Why do we care about the doors? It's because all of these add up after a while into that larger special character. So again, this is all about due process, which is that's part of the fundamentals of the fair play that our laws in this country and the Constitution, state and federal, mandate. So the due process aspect here is, and again, it's embedded in the law, is to inform adjacent owners when you have a COA coming up, plus others entitled to receive notice under the local regulation. That's where you're going to need to be working with your staff to figure out who those entitled to receive notice are, because the local regulation will likely set that out at this point. As I mentioned before, for quasi-judicial, it needs to be what's considered really a public evidentiary hearing. Oaths are taken by the those giving testimony, because it's judicial, quasi-judicial. You need to make sure you're following the North Carolina Open Meetings Law, which if you have staff, I presume you are. There's also some training you can take on open meetings law as well. And we have special situation now with the COVID emergency where we can have virtual meetings and so forth. So that's something to monitor as things get back to the norm we expect. We might not be able to do virtual meetings in the future, but who knows? Also, it's very important for due process, constituent service, but especially due process, that you make sure that you are reviewing and acting on these COA applications no more than 180 days after filing. You can't sit on it forever. You know, that if you go past that time, you may be trampling on someone's due process rights, frankly, and setting yourself up for some unpleasantness through litigation and likewise. HPO, we're here through the statutes at your invitation. You can ask us for advice. It's not binding on you what our advice is, but if you have a question, let's say about substitute materials, you don't know anything about this new substitute material that someone has offered up as how they would like to change or update their home, we can provide that to you, and Christy can help you organize that through the local government program. Appeals, the appeals changed a little bit. So if there is an administrative appeal of a minor work, that goes to the commission. Now, I don't hear of that happening very often these days, but it could. But the commission, in the old days, when 160A was in play, it went to the Board of Adjustment. Well, now we have sort of a split approach. You need to look at your local ordinance to figure out what your local community has decided to do. It can go to the Board of Adjustment, but if your local regulation doesn't provide for the Board of Adjustment, it would go straight to Superior Court. So just remember, it could go, you know, sort of like Robert Frost, it can go in one of two paths. You need to look to your local regulation to figure out where yours goes now. Now there's a special provision that existed in 160A and it survived in 160D. If it is a state-owned property, then the appeal does not go through the Board of Adjustment. It does not go to the Superior Court. It goes to an organization, entity, a statutorily created entity called the North Carolina Historical Commission. And their decision is based on the Secretary of the Interior standards, and it is a final and binding decision. And in my decade with the state now, I can think of one time that this has happened. So it's very rare, but it's possible. Certain changes are not prohibited. This stayed exactly the same. And this is a question in your ordinance, how you are defining this. Ordinary maintenance or repair, not a change in design, material, or appearance. So this is a question of what is actually, how are you defining that? Because it's not, what I have here is about as much as is defined in the statute. Public safety. Public safety, for example, if the building's about to fall down, you know, there's been a tornado or something. The building is about to fall down. There needs to be something that happens quickly. If there is a public safety aspect, again, certified by, quote, a building inspector or similar official, in a case like that, then that trumps the COA process. Now, what you're doing through design review, your legal authority does not cover the use of the property. If the owner is allowed to use that property and is not prohibited by some other law, what comes to you is not a matter of, well, I think you should have a restaurant instead of the beauty shop there, for example. The use of the property is not really under your jurisdiction. This is a very North Carolina centric thing. What I'm about to explain here is many states have demolition denial. North Carolina, as a default, instead has demolition delay. And under the law, up to 365 days of delay is allowed. The commission can even reduce that time period if you find that the owner will suffer extreme hardship, which is not really defined in the statute, or the owner is permanently deprived of all beneficial use or return by virtue of the delay. You can even waive the time if you don't believe that there's any special significance or value in retaining the property towards the character of the district. However, if there has been a pending designation, it's coming up to the city council or the town or the county commission, but it's not yet been finally approved, then there is a 180-day delay in this. It's a shortened time period. Now, there is one way to give you a tool. It does not mandate that you deny demolition, but it gives you a tool for you to deny demolition or destruction if you so choose, and that is for a property to be found of statewide significance. There are very few properties that commissions or local governments have put forward to the State Historic Preservation Officer, who is our Deputy Secretary of Archives and History, to determine whether or not that property is of statewide significance. I will say, as a cautionary tale, this is a Wilmington case from a long time ago. It only went up through the Superior Court, so it's not precedential value. There's not a Court of Appeals or Supreme Court case on it. But it is very interesting because Babies Hospital was the Babies Hospital. It was a landmark building in Wilmington. And there was an effort to demolish it, which it ultimately was demolished, but the statewide significance process was started after the COA for demolition was filed. So the timing was not what it should have been there. So our recommendation is, if you would like to have a property judged as to its statewide significance, you need to do that before there's any threat to the building or before a demolition COA is put in play. I just want to flag the next bullet point. We could spend a lot of time talking about this, and we might do a special presentation in the future on this, but demolition by neglect. Now, demolition by neglect is not the same as active demolition where someone comes and the building disappears in a day because of, you've got machinery and so forth. Demolition by neglect is where it is being allowed to fall down through inaction. This is complex. We can have a lot of points to talk about here, but there is an undue economic hardship aspect to this. So this ordinance sometimes is embedded with the local preservation regulations that set up the commission. Sometimes it's a standalone ordinance. So I just point that out for you. That is allowed, but there's a lot more to it than just this one bullet point. Conflicts with other laws. This sometimes comes up, and this is something to really flag for your local municipal or county attorney. If there's a longer waiting period or higher standard embedded in your preservation regulations, then the preservation regulation trumps. Otherwise, the other laws govern. So it's a matter of like the strictness, how that's playing against the others. And sometimes this does come into play. We've had questions about, for example, solar arrays being erected around or on a building itself. So there's state laws that deal with that and local laws that deal with that. So that's the kind of thing where you need to see how those dovetail together. And then there's a remedies section as well. There's some case law about this. We won't go into that today, but I do want to let you know that there there is a remedies aspect to the law as well that did survive in the 160D changeover. Appropriations. We always ask each year with our survey of all the certified local governments, asking them how their year has gone. How many of you have a budget? And we've seen it creeping up that communities do have a budget for preservation, but many commissions don't, and they don't even have money to go and travel to our trainings and so forth, or to do professional development. So I would say, you know, if this is something that you would like to investigate further, it's something you need to discuss with your community, and the governing board is allowed to appropriate dollars for expenses of the commission, plus additional money for designated properties that you might have some acquisition, or you're dealing with it in some way as a land preservation aspect. So the expenses of the commission, to me, that's something that everyone should be investigating further. Now, here's some food for thought. And again, I've tried to set this up based on the powers that we've talked about today. You know, you may have a situation where someone has become ill, long-term illness. There might be some absenteeism going on that they don't have any control over, but you start to have a quorum issue. So do you have a means to remove members for cause so that you don't run into a quorum issue because there's someone who can't come because there's a situation out of their own individual control? Your designations, we talked about this too, is the more that you can articulate your designations and point to that significance and the integrity equation that we talked about, and really tease out the special character by describing setbacks, describing the streetscape, describing the materials, all those things that are subject to a certificate of appropriateness inquiry. That's very helpful on the front end when you do the designations. Again, I've talked about the deadlines for making decisions. You know, make sure really that you're making those timely decisions. And again, we've talked about design standards. The more they can be understood by the average person, architect's one thing, but by the average person, the average homeowner, building owner, that's even better. We've talked about budget. And also, if you don't know your local council, I would really encourage you to get to know your town or county commission legal counsel, because I really like to see you all have some educational materials, some tools to help your constituents understand how to get through your process, but also to understand why your community has this program and why you are trying to preserve various historic resources in your community. So I just want to thank you all so much for coming and joining us today. It's really a delight to be able to use this technology to visit with you and to continue with our local training, which we really enjoy being with you. We usually have at least 3 regional trainings a year. So we're hopeful that in the future we'll be able to resume that. But we'll be having these for a few weeks and continuing to add to what I'm calling HPO TV now. So if you have questions, please send them to Christy. We will work through the listserv to get answers to questions. And at this point, I'll turn it back over to Christy. I will stop sharing as well.
Thank you, Ramona. That was very helpful and answered a whole lot of questions. If you have further questions, please feel free to email us. This concludes our second session of the CLG virtual training series. We plan to release at least 1 new session each week, and we'll notify you once it's uploaded to our YouTube channel. Please email us with any questions or comments. We welcome your feedback. Thank you for joining us.
And we thank you for your preservation partnership. Bye now.